court will now proceed to consider the third case on today's docket, the Agency for Healthcare Administration versus Ybor Medical Injury and Accident Clinic.
Good morning. May it please the court, my name is Tracy George and I represent the Agency for Healthcare Administration, or AHCA, the appellant in this case. I would like to cede 5 minutes of time to Rachel Siegel, Deputy Solicitor General, who represents the amicus state of Florida, and reserve 3 minutes for rebuttal. The question before this court is whether AHCA's final order deeming a licensure renewal application incomplete and withdrawn from further consideration is an agency decision that has the effect of suspending or revoking a license for purposes of Section 120.683's presumptive supersedious provision. In this case, Ybor Clinic failed to timely complete its licensure renewal application. As required by the healthcare licensing laws, AHCA deemed the application incomplete and withdrawn from review by final order. AHCA also exercised its discretionary authority to grant a 30-day grace period on the license so that the facility could wrap up operations and safely discharge its clients. Ybor Clinic appealed and moved the second DCA for a stay of the final order as a matter of right pursuant to the presumptive supersedious provision. AHCA pointed out the provision was inapplicable and that a stay is discretionary upon consideration of the case law factors, but the second DCA disagreed, granted the stay as a matter of right, and certified conflict with the first DCA's order in Beach Club. AHCA sought review and this court has granted jurisdiction. As this court has recognized previously in Osborne Stern and in Davis, disciplinary proceedings in which an agency suspends or revokes an existing license and the bundle of rights associated with that license, and regulatory proceedings in which an agency considers an application for a prospective license the applicant has no legal right or expectation to, are fundamentally distinct and follow separate tracks. There are different things at stake, different burdens of proof that apply to different parties, and we believe different stay standards. When you are talking about a disciplinary action involving the suspension or revocation of an existing license, the licensee has a legal right and a legal expectation for the license for the effective period of the license. So they're allowed to operate during that. That's the bundle of rights that they have. When AHCA suspends or revokes a license, it's taking away those rights. So that's why there's a heightened standard.
Could you direct us to, I know in your brief you said that you acknowledge that, you know, the effect of language kind of expands the category of agency decisions beyond, you know, an explicit suspension or revocation. What would be, and you gave kind of an example of something that, you know, so restricted or limited, but what would are there specific statutes we should be looking at that authorize agencies to do things to a license that are not suspension or revocation but could have that effect?
Your Honor, one thing that we found is that some agencies are permitted to withdraw a license. This is not a disciplinary action, although most times we believe this statute would apply to discipline, but it's, for instance, if they've issued too many. So, for example, we found that there is under 616.153, the Department of Agriculture can withdraw a permit for a fair association to hold an annual public fair if it later finds that it will compete with another fair association application. So that's an example of where there's a right that someone has, which is to their license, to their permit, and the agency is allowed to take it away, but it isn't called a suspension or a revocation. So that's an example of where it might apply specifically. I'm sure that it would have other applications, you know.
It seems distinguishable, though, because that sounds like a recurring event. Like, you know, I could imagine an expectation on the part of that permit holder if it's a fair that happens every year to be a little different from the right to operate vel non, right?
Well, I don't believe that, I mean, certainly that could happen, Your Honor, but I think that there's also an equal expectation that if you file your application and it's incomplete, it's going to be withdrawn. The statute requires us to do that. So you know, I mean, I don't think that the amount of times that something happens is necessarily determinative of whether the statute would apply. You know, and keep in mind, it would also happen when an agency does something it shouldn't. You know, as one of our justices here pointed out, if the agency were to put limitations on a license that were so restrictive the individual couldn't actually use it, that would be an example of where the agency has essentially suspended or revoked a license but hasn't called it that, so it has the same effect. So I think that the statute is not necessarily intended always to address something that happens, but maybe to address something that shouldn't happen, right? So keep agencies honest, doing what they're supposed to be doing. Again, regulatory actions involving an application for licensure or licensure renewal, the applicant has no legal right or expectation to continue licensure. Their license will expire by operation of law if you don't file your application on time. So when you've got the stay in these situations, you're actually granting rights that the individual doesn't have otherwise, which is very different than a revocation where you're having you're trying to preserve the status quo of the license that someone has for a period of time. So instead, you know, for instance, this particular applicant that we're talking about in this case had a 2-year license. It would have expired, I believe, in October 2019, and they're still operating under that same license. They basically have gotten 2 additional years of licensure without having to prove they've met the minimum requirements of law. And that's problematic. I mean, you think about how many applications there are out there for how many different agencies. Our agency in particular licenses 18,600 facilities, healthcare facilities throughout the state. That's about 5,000 renewal applications a year, keeping in mind there are initial and change of ownership and things like that. So that's a lot of applications. This is not, however, a normal situation for us. We only have about 15 of these a year that we deem incomplete and withdrawn from review. So this is not a situation where the agency is wanting to not grant licenses. This is just the applicant doesn't meet its statutory obligation to file a complete application. And we believe that a stay should be discretionary in these circumstances because it's unnecessary to preserve the status quo of an application. The stay will again afford rights that an individual is not otherwise entitled to under the healthcare licensing statute. And all of this without considering the case law factors such as successive likelihood of success on the merits of the case.
I mean, it may or may not make sense to preserve the status quo, but the point is the legislature hasn't said that it should automatically be preserved. If we define the status quo as the application still being alive, which then has the effect of keeping the existing license, kind of the expiration of that tolled. I mean, that's the status quo we're talking about, right?
Well, I would disagree because the individual only has a right to a license for the length of the license, the 2-year period. After that, it's extended by operation of the statute, and here we've extended it under our discretion. But you only have a right to that 2-year license, and if we were to grant another license, it would abut that license. It wouldn't be that you start 2 years later. So if we were to grant, so
I'm sorry, but the statute says that during the pendency of the agency's review, the existing license, if it were to expire during that pendency of review, the expiration doesn't happen, it gets tolled, right?
Yes, Your Honor.
And so if you administratively withdraw an application, if there were an automatic stay, the effect of the stay would be to keep the application non-withdrawn, which would have the effect of keeping the pre-existing license alive. I mean, so I'm not disagreeing with you. My point is just, if the status quo, you know, the likelihood of, you know, the agency having been wrong, whatever, all the factors that a court could look at, the point isn't that a company is going to be left high and dry if it seems to the appeals court that, you know, that something might really be wrong here. The point is just whether do you have to establish that if you're the company, or do you get the benefit of the automatic statutory stay?
Right. And there's 2 points I'd like to respond to that with. First, keep in mind that 120 is a very broad statutory scheme. It applies to every agency. I think that this particular provision is not very consistent with the Healthcare Licensing Procedures Act, which makes it very clear you get a 2-year license. If you don't complete your application, the agency has no discretion but to withdraw it. Okay, so I think they're inconsistent. The second thing is that, oh goodness, I've lost my train of thought. The second thing is that there are additional negative legal consequences that come along with suspending or revoking a license that you do not see in the withdrawal situation. For instance, yeah, you lose your license for a short period during either one, although there's some. If you'd filed a second application, we could have processed that before your license expired. But when you suspend or revoke a license, the agency can then deny any future licenses that you apply for, even if it's a different license type, for you or your controlling interest. That's a big deal. It also interrupts things that coincide with the license, like a lease, an insurance agreement, things like that. They're supposed to go along sort of with the 2-year renewal period. It can cause you to experience other legal actions, like Medicare or Medicaid could withdraw your participation with cause. And of course, there's stigma involved when you revoke or suspend a license.
But you don't
So
want us to be
different.
looking at, I mean, isn't this the interpretive question here, just whether the agency decision has the effect of taking away someone's legal authority to operate? I mean, once we start getting into like what are all these like secondary effects of losing a license, I mean, then that plays into the other side's argument that we should be comparing kind of the predicament of someone who, you know, doesn't get their license renewed to the predicament of someone who has their license suspended. I mean, that more abstract understanding of the effect of withdrawal or of revocation or suspension, I mean, that helps them.
The difference is that here we are not acting on the license. The statute says it has to have the effect of suspending or withdrawing a license. Here, the agency has done nothing that has that effect itself. The expiration is by statute. So we're not acting on the license, we're acting on an application, and the Healthcare Licensing Procedures Act says that if the individual doesn't complete their application, then the agency must suspend or withdraw. It does not make sense if the Healthcare Licensing Procedures Act says you get a 2-year license by pursuant to a stay to have an actual 3 to 5 year license because of these types of proceedings, these stays. Think about it this way. If we were to apply the presumptive supersedious provision to these incomplete applications, what would happen? If an individual thinks that their license is likely to expire, they could just basically submit an application with their name on it and sit back for 5 years while they go through all the litigative process and get their license for that long.
You are
Doesn't make
consuming your
sense.
rebuttal time. You can keep going, but you are
Oh, I'm
consuming it.
sorry. Yes, you know what? I didn't.
No, she's got her time.
Okay, thank you.
Mr. Chief Justice, and may it please the court, I'm Rachel Siegel, and I'm appearing for the state today as amicus in support of the agency. With the few minutes that I have, I'd like to focus on a few key points. I'd like to begin by responding further to a question posed by Justice Muniz about other statutes we can look at that authorize actions on a license that aren't just suspensions or revocations. And I'd direct you to Chapter 120, Section 60, licensing, provisions 5 and 6 mention revocation, suspension, also annulment and withdrawal of licenses. And Section 6 talks about the restriction or limitation of a license. So the text of the automatic stay provision the broadening effect of the words has the effect of a revocation or suspension was meant to encompass terms such as these. I think it's also important to keep in mind that the automatic stay provision is in the APA generally, but it is meant to apply to all agencies statewide. And many of those agencies have their own governing statutory regimes and certainly may have their own terms that they would use instead of suspension or revocation. But I'd like to emphasize that the text of the statute here uses the words suspend or revoke. And what's important is that both of those words are about cutting short or taking back something that was previously bestowed upon the licensee. So it's wrong to say that the effect of a revocation or a suspension of a license is the downstream attenuated consequence of the shutting down of a business. The effect of revoking or suspending a license is just the legal effect of that act, namely that you no longer have the license. That's really all that it's doing. It's taking back the licensee's right to operate under that license. And it changes. It doesn't necessarily prevent the licensee from continuing to operate. It's just at the licensee's own risk because it no longer has a license. And the reason why denials or withdrawals of renewal applications do not entitle an applicant to an automatic stay is because there is no right that's being cut short or taken back. The license, if petitioner here, if Ybor here had applied earlier in the process for their renewal license and it had been denied while their original license was still in existence before the expiration date, it would not have had the effect of putting them out of business. They would have still continued to operate under the terms of the original license. They had the right that they always had from the agency, and that never changed, and that doesn't change. It's an application. It isn't a license. And when you submit an application, you don't have a right to anything. I'd also like to spend a moment. Actually, I won't spend a moment. I see my time has expired.
I'll give you another 30 or 45 seconds.
Thank you so much, Mr. Chief Justice. I just want to spend a moment to talk about the statutory grace period while a renewal application is pending. The fact that this statutory grace period exists and allows a licensee to continue operating past the expiration date on the license itself, so long as the agency is still considering its renewal application, does not have the effect of a revocation or suspension because the duration of the statutory grace period has always been tied to however long it's going to take the agency to rule on the application, and the potential licensee has just no idea how long they might be able to stay open There's no expectation created. There's certainly no right. There's just really nothing. And whenever the agency rules, the statutory grace period ends, and that's the end of the matter. No legal right was affirmatively cut short or taken back by the agency, and that's why the stay doesn't apply. Thank you very much.
Thank you.
May it please the court, my name is Frank Bain with Noblesse Oblige Charities Legal Services. I represent Ybor Injury and Accident Clinic. My co-counsel is John Terrell from the law office of John Terrell here in Tallahassee. Before I get started, I'd like to remind the court that Ybor Clinic has been in business for 19 years. Every 2 years during that period of time, they have renewed their license until the most recent renewal period when they ran into problems. Now, the issue before the court today is whether an application to renew a medical clinic license that is withdrawn from consideration by the agency qualifies for the presumption of supersedious under the statute 120.683. Now, that statute reads in part, if the agency decision has the effect of suspending or revoking a license, supersedious shall be granted as a matter of right. Now, the second district ruled in the Ybor Clinic case that the agency does qualify, that the order of the agency does qualify for the automatic stay under section 120.68 because that withdraws a renewal application because it has the effect of closing a business, just as a license suspension or revocation would. The first
that's
district.
not exactly what it's about, though. I mean, it's about whether it has the effect of revocation or a suspension. And it just seems like the effect of not renewing seems to me to be just categorically different. I understand it may have some of the same real-world consequences, but particularly we have these other things in the statutes that where other terms than suspension or revocation are used, but are essentially the equivalent, have the equivalent effect of an existing license. It seems to expand the scope to this renewal process that seems to be stretching the language. So tell me why I'm wrong. I know you think I'm wrong, so tell me why.
Because the clinic's been in operation for 19 years, and the effect is taken in the context of a stay, the purpose of which is to preserve the status quo below the appeal court. And the reason you preserve the status quo below the appeal court is so they have time to make their decision. And when they make their decision, it can take effect. Now, the Florida law has made an exception for cases that involve licensing, because they know, I guess I can't show the pure reason that the legislature did it. Legislature made these laws, but I assume it's because if they lose their license and go out of business, any decision that the appeal court might make would be rendered ineffective before it's even made. So the effect that's important in this case is the effect of shutting down the business rather than...
So this would also come into play, under your theory, if there's a denial of the application.
Yes, the denial of the application, anything that has the effect of shutting the business down would fall under section 120.68.
It just seems like that's be a very strange way for that language to operate, because you've got this existing license, and then you've got a new license, a renewed license, and to treat a denial in the same way that you would treat of the new license, in the same way you'd treat the suspension. Seems like the legislature would have thought about that separately.
Well, we see a distinction between an actual new license As the second district mentioned in their opinion, there is a difference between, I think Show Club is a case in point here, where a business was making an initial application for a license. And if such a license is denied, it doesn't shut down a going concern, a business that's already in operation. But a renewal license is different because the business is in operation and it has the effect of a suspension or a revocation because a business that's already up and operating has to shut its doors.
As counsel and your colleague on the other side, though, noted, and I understand in the real world things might not happen this quickly very often, but you know, if the licensee applies on day 120 before the expiration, the agency could, you know, administratively withdraw or deny the license application with sufficient time that the original license hasn't expired. And so in that scenario, the agency's decision literally has no effect whatsoever on the license. It doesn't cause anyone to go out of business or anything. I mean, you know, assuming in the real world you don't have enough time to get a new application in, whatever that might happen. But I mean, literally, there are scenarios where there is no effect whatsoever on the license, and you're asking us to say that that decision has the effect of suspending or revoking the license. So that just doesn't seem possible.
It has the effect on the business of shutting down the business. There seems to be a disagreement between AHCA and Ybor Clinic on what the effect is upon. The effect is upon the business by shutting it down.
Well, I presume, though, that you'd agree that the statute reflects a purposeful legislative choice, right? The legislature could have said any ruling or decision that has the effect of suspending the business's operations. Didn't say that, doesn't say that. All it says is that it has the effect of revocation of a license, which seems to me to be a purposeful legislative choice to focus on the licensure rather than the operations of the business. Help me understand why that's wrong. Because the legislature could have said what you're saying. It just doesn't say that.
Well, the legislature, it would have been helpful, of course, if they would have mentioned what sort of effects they had in mind at the time they wrote the law. Well, the second district thought that the effect was upon the business. The license itself, I understand that they expire every 2 years, but they don't automatically expire. There are provisions in there that prevent them from going into expiration, getting your application in, and renewing prior to the time of the expiration date. If the agency issues the order, which stops that process, then the business has to shut down or go into litigation. I don't know if that answers your question.
I'm not sure it does. In fact, I think it kind of points to a weakness in your position because, as you just said, it could enter litigation, right? The result of having your application for a renewal lapse or be withdrawn might lead to something other than the business being shut down. You might sue. You might, write or undertake some sort of unlicensed operation for a time being, or shift into another line of business while the matter is pending litigation. It just doesn't seem to me to be contiguous with shutting the business down. And if the legislature had intended, if the legislated bargain had been, that's what we want, that's what the words of the statute would say, seems to me.
Well, when the legislature wrote the words, having the effect of, there was already, we have a rule of procedure 9.190, forget the exact thing, where they say that if it is an actual revocation or an actual suspension, then supersedious is granted as a matter of right in those cases. This particular law, statute 120.683, broadens the number of litigants that are included under that same umbrella by including people other than people who have an actual suspension or revocation. So it has to include other kinds of cases besides just those two. And we presume that a case like this, where the business, a going concern, is shut down, should be included under that supersedious provision of section 120.68.
Arguably, counsel, the action is by, in this case, your client. They didn't fill out the application properly. It's not that the agency did anything to pull back a right that they had. It was something that your client had to do proactively to renew an application that they didn't do properly, and per statute that had to be withdrawn. So I'm still not sure how that has the effect of suspending or revoking a license. Your original license was in effect, and the fact that you didn't have an application pending anymore to get a new license doesn't seem to be suspending or revoking the license itself by the agency.
Well, the agency did issue an order deeming the license incomplete and withdrawing from further consideration. So there was an actual order coming from the agency. Eliminating the opportunity of having that particular license application reviewed.
Essentially, it's just the fact that they issued an order at all, you think that affects the license or the process of running the business in any way falls under this presumptive stay?
Well, the statute itself, the wording of the statute says that it has to be an order, and the order has to come from an agency, and the order from the agency has to have the effect of a suspension or revocation. And the first two parts of the three-pronged test is, yes, we have an order and we have it coming from an agency. I think the real crux of the issue here is the meaning of the language having the effect of a suspension or revocation. And our position, of course, is that shutting down the business is having the effect that a suspension or revocation would have upon that business.
Let me propose an alternate reading that your colleagues on the other side make, and perhaps hear your response to it. What if the sense in which one action or one agency determination might have the effect of revocation is that a revocation is punitive, right?
Mm-hmm.
It's a penalty that attaches to some deviation from appropriate license behavior. What happened to your client is not punitive, right?
Correct.
So it doesn't have the effect of a punishment, right?
That's correct. It doesn't have the effect of a punishment, but it has the effect of putting a business or stopping a business during the pendency of the appeal.
I understand that that's one effect of it, but I guess what the statute says is a little less helpful to your position. It has the effect of revocation. And I guess what I'm curious about your answer to is, what if the relevant effect of revocation that we're talking about in the statute is penalty, as opposed to some impact on the profitability of the enterprise?
We don't think the relative effect is that it's relevant whether or not it's punitive or whether it's regulatory. We think the thing that matters is whether a business is able to stay open during the pendency of its appeal. This whole statute is about supersedious. It's about the issuance of a stay. And the issuance of a stay has a purpose: to keep people, to preserve the status quo so that the decision can be made without having the decision be made by having the appellant be driven into bankruptcy, so that the appellate court, so that its decision would be rendered ineffective. I'd also add that that would be a waste. Not only would that be an injustice to the appellant business that is shut down, but it would also be a waste of judicial resources for the district courts if they take an appeal, and then when they get through a portion of it, all of a sudden the appellant is bankrupt, and then the case just kind of goes up in a puff of smoke, and they've wasted their time on it. I'd like to mention, I guess, just shortly address the amicus brief filed by the Attorney General's office in this case. To quote their amicus brief, they feel that the Second District's interpretation of Section 120.68 risks seriously damaging the efficient operation of the administrative scheme. Their point seems to be that the Second District's reading of 120.68 would introduce a kind of moral hazard where undeserving renewal applicants would simply extend their licenses by filing an appeal and in the process flood the system with meritless appeals. We'd like to point out that there's an opposite hazard, that if the First District's interpretation of the statute is affirmed, then many deserving renewal applicants will succumb to financial ruin before the court can rule on the merits of their case.
You need to sum up. He's not taking your time. Don't worry.
That's okay.
Don't worry. I'm going to keep your time. If you could sum up in another 30 seconds or so.
Well, I'm actually finished. I was going to
Okay.
defer to Mr. Terrell here anyway.
Very good. Thank you.
May it please the court. My name is John Terrell, and I also represent Ybor Medical Clinic. I wanted to go back to the question about whether this is a new license or a continuation. And there's something that AHCA did not cover, but I'd like to cover, is that when these applicants apply for an initial license, there's a lot more involved in that. The new applicant has to file paperwork, and this is 408-810, on their financial ability to practice for 2 years. So they have to go through that burden and show that they can maintain the business, and so they have to do a lot of financial stuff on that. They need to do zoning. That's a whole new different thing. And background screening is much more complicated. When you get to the renewal license, and this is why I think they keep the number the same, the renewal license is a whole lot easier. You just have to, your zoning's done, you don't have to worry about the financials, you've been in business for 2+ years, you've shown that you've met the minimum requirements for practicing in whatever field you're in, it's a whole lot easier. So when they say, oh no, there's no effect on you if we do this withdrawal, yes there is. Because if they withdraw it and there's no stay granted and you start all over, you have that long list of things to do. Whereas, and going back to the question here, is that these withdrawals, they're treated just like denials. You get your 120 rights, your 120.57, 120.569, where you can contest what the agency said is missing from your application. So that's what we're really looking at is this a license that continues? Yes, it is. The renewals are a whole lot easier because you've already proven your ability to practice. It's just done much easier. And then when I know the agency mentioned at one point that there's possibly public harm, I would disagree with that because when you're looking at these stays, first, whatever applicant is in front of you, they've been practicing for at least 2 years, and in this case, 10+ years. So they've been proving that they can practice with the standards that they need to operate safely. Then what AHCA is completely ignoring is their whole enforcement portion of it. Not only can they come to the court and say we need to modify this stay because there's some kind of safety issue, they have emergency suspension orders, they have moratoriums, they have administrative complaints, and during this stay period, there's nothing in the law that says that they can't go and file administrative complaints or emergency suspension orders against these facilities if they think there's something operating, if they're causing a danger to the public. So that's another crucial thing is that, there's this perception made by AHCA that, granting these stays could cause problems. I don't think so. I think what we're looking at is exactly what's in that statute. If what they're doing, which is a withdrawal, is very similar to a denial, is having the effect of putting this place not only out of business, but basically at ground zero. You're a new applicant, you start all over, it's a hurdle. And the burden of proof for an initial applicant is higher than for a new renewal. applicant. So I think that's some of the effects that, Judge, I would bring up here as far as when you want to say effect of. And interestingly, while we were waiting in the lounge, I happened to look at the Black's Law's Dictionary, and just to see what effect meant. And it was outcome or consequence. And quite frankly, when they do this kind of withdrawal, the outcome and consequence is not only are they out of business, but they start at ground zero again in the whole application process. And that is an effect that's very similar to suspension and revocation. That's it. Thank you.
Thank you. Buttle?
I would have to disagree with my colleague here about new applications being from ground zero. What happens when someone has to file a new initial application, for instance, if they didn't get a timely and complete renewal application in, is that the agency can expedite the process for reviewing that application. They may be fined for a few days if they're operating without a license, or they may not be able to bill, but they don't have to completely disband their operations. There may be a few more things they need to include in their initial application, but guess what? They've had here, the litigation's been going on how long? They can get all their ducks in a row and file this application tomorrow. And this is not a huge effect on the business. And the legislature's already made the policy decision that when someone fails to get their renewal application in on time and complete it, that they do have to file a new initial application, and that the burden is on the applicant to do that. And it's not on the agency to go around chasing everyone saying you need to get your application in. Oh, and by the way, you get a stay for a really long time, and the agency's going to have to go out there and monitor you and make sure you're following the law during that period because you didn't show us that you met the initial minimum requirements for licensure. So this is a burden flipping, right? You're putting the burden on the agency to allow them to stay operating when the burden was on them to stay operating, to complete their application. And I think that does interfere with the whole application renewal system that the legislature put in place, particularly with this healthcare licensing statute. If no one has any other questions, I will wrap